Hello everyone, welcome to our webinar on the new whistleblower laws. My name's James Field, I'm the CEO of CompliSpace and one of the co-founders. I'll walk you through this today. By the looks of the registration numbers, there's a fair bit of interest in this space, and not surprisingly when you actually go through the complexity of the law that we've got in front of us. A couple of housekeeping matters just at the beginning. If you can submit any questions that you have through the chat line that we have, and what we'll do is we'll collate those at the end of the webinar, and we'll actually respond back with written answers to those questions. So I'll kick it off and just give you an overview of what we're going to go through today. First of all, we're going to look at very basic whistleblower concepts, just the key things, difference between a policy and a program, so on and so forth. The next two sections are really dealing with, why have a whistleblower program, what are the benefits and what are the key elements. The middle of the process, we're going to go through the Corporations Act. There are not all disclosures are court or qualified under the Corporations Act, so we need to, before you can be protected, talk about which disclosures are actually court, and then the protections themselves. The last three sections are really talking about operational issues within schools with respect to implementing a whistleblower program, which is probably some of the key information that you're looking for. So I'll kick it off with the key whistleblower concepts. What is a whistleblower? A whistleblower is an insider within an organisation. That's the first part. It's somebody that has knowledge with respect to your organisation, and the disclosure that they make is outside of your normal existing internal reporting channels, and they can make it either anonymously or not, and the disclosure itself should relate to serious misconduct that occurred within the organisation itself. So that's a very basic definition. There is actually no official definition. It's not a defined term. There was an Australian standard in 2003 that did have a definition. However, that definition really wasn't very helpful when we looked at it, so we've gone with this one. So what's a whistleblower policy? In essence, what it is, it's a public-facing document that you publish that allows the whistleblower or the person considering making a disclosure to understand the process. So what are the protections available? How do I actually make a disclosure? Who am I making to it? What sort of support will I get and protections? If there is an investigation, what's the investigation? What's going to happen with that? And if I implicate people in this and I'm raising it, how will they be treated? Now, that summary is actually taken out of the Corporations Act. The key here is that the whistleblower policy is like a summary, if you like, that you're providing to people that would potentially be blowing the whistle in an organisation. It is quite distinct from a whistleblower program. So think of a whistleblower program as all the internal governance mechanisms that you have to have in place to make sure that your whistleblower service, if you like, is actually working effectively. And just to give you a very high level sort of view of what that might look like, hopefully most of you will be familiar with our PLAR concept, which very quickly explained is that anyone can have a policy in place, and if you just have a whistleblower policy in place, and you have it hidden on an F drive or something like that, it's not going to really help anybody. So you've got to have policies, and you've even further got to have policies outside the basic whistleblower policy. But the essence of it, you have to have some sort of learning. You have to have education for people as to how they're actually going to blow the whistle and what it all means. And I'll go through that in a little bit more detail. And obviously that learning also applies to the whistleblower protection officers themselves and the people within a school who are managing the whistleblower process itself. The assurance part of the process is how are you actually capturing these disclosures that are being provided, how are you reporting on them, and so on and so forth. So yeah, that's the essence of a whistleblower program, and I'm going to go into more detail as to what that entails. So some of you may have seen a diagram similar to this if you've been through any privacy presentations, because it's very, very similar. And that the whistleblower policy itself is just really the public-facing document, which is a summary of how you do things. But it's actually the whistleblower program that is the guts, and you need to have the program to allow you to understand how you're going to actually manage the whistleblower service as a whole. If you don't have the program in place, essentially the policy just sits up the top, and it won't work in practice, because people won't know what to do when they receive it. You'll get confused when it comes to how you're going to report things. So there is a very clear distinction between the two. So why have a whistleblower program? Well, the first thing is that ethical organisations, and most organisations these days will say, you know, high standards of ethics and values, and that's certainly the case in schools. And if you want to ensure that you have a highly ethical organisation and that the values are actually carried out, they're just not being paid lip service to, one of the keys is you've got to understand when these things, when there's breaches of your codes of conduct and so on and so forth. So the commitment to the ethical behaviour is the starting point for any whistleblower organisation putting in a whistleblower program. But then the real question that you've got is, who's best placed to actually see the things that are going on as far as, you know, potentially serious misconduct in an organisation? And what's really apparent is it's not usually the directors of an organisation, because, you know, they attend X number of meetings a year for a few hours, so they're not really well placed. If you think about it, a principal and senior leadership team isn't that well placed either. Quite often information is filtered to the senior executives in organisations, and the people that are really the best placed to see serious misconduct are the people are actually employees. They're the most obvious, but it's a much more extended group than that, especially in the school sector. So it's your suppliers, so they may see things like bribery and corruption, but it's also your students, and it's your the parents, and it's other key stakeholders that you might have. And what you're doing by putting in a whistleblower program is providing them with a mechanism to communicate directly to your school without fear of reprisal. So why don't people speak up? The most common reason that people don't speak up is that they don't actually know how to do it. And when I say that, they obviously know how to speak, but they don't understand the mechanisms in place. Now, the normal mechanisms in place are what we'll call internal reporting procedures within an organisation. So that might be a complaint system or an internal grievance process, or you might have procedures for reporting bullying and so on and so forth. If those mechanisms aren't clear, people really don't know how to speak up even internally. So if they really want to get to the top of an organisation, they need a clear system that allows them to do that, because the second thing that they're worried about is, of course, victimisation. So then all the excuses come. If we see an incident occur, you know, the brown paper bag being slipped between people, or, you know, it could be a potential child abuse issue, people might look at it and go, actually, you know, I thought I saw that, but I'm not quite sure. I don't really know where to report it. I don't want to be involved. I might just ignore it. And if you don't have a whistleblower system and you don't have strong internal reporting procedures, that's exactly what people do. They don't report it, and it comes back at you. So for the visually inclined, the basic concept is this: the whistleblower who sits really outside the organisation, if you like. They're an employee, but they're a key stakeholder in the organisation, and they want to get this message up to the highest levels of the organisation. So what they actually do is, you know, they look and say, how do I get it there? The whistleblower program allows them to present anonymously, if they require, to a whistleblower officer, protection officer, and that person's role is actually to protect the whistleblower, and then to gather that information and have an investigation carried out and report what is needed to be reported to the people internally within an organisation. So that's the essence of how whistleblower service works. So the benefits are, number one is that the risks are identified early, and you know, whether it be a fraud or something like that, you want to know whether it's being carried out a long way before you get to the back end of that. Now it's quite common. We've seen lots of fraud occur in schools and other things. But if someone was aware of it, you could have stopped that 2 or 3 years before. And I think the average fraud actually goes on for 18 months or so, and you could have picked that up early. So what a whistleblower allows you to do is take control up front in these situations. The reverse of that is you're not sticking your head in the sand. And it might feel good that you don't know these things, but ultimately it's going to come back and bite you. And there's some pretty good evidence out there that happens, because we've had 4 royal commissions that are, I'm sure everyone is familiar with. So the Child Protection Royal Commission, the Banking Royal Commission, the Aged Care Royal Commission, and we're also going to have a Disability Sector Royal Commission. And essentially what happens is all those things that happened are now coming out. So where people had stuck their heads in the sand and ignored them and deliberately ignored things, they're paying the penalty for that now. Much better to take control up front. If you take control up front, obviously you're protecting the directors and the managers, so those people who have personal liability within organisations. Absolutely critical to have a whistleblower system in place to actually protect them. We'll go further into this when we talk about the Corporations Act protections themselves. And then obviously, if you think about the fees that are paid into the Royal Commission and other places, you know, when these things happen, when these serious incidents happen, what people tend to do is, you know, and I'm sure a lot of you have been in that situation, and you've had to deal with litigation or some sort of an offence, and suddenly the checkbook seems to be open for, and all the budgets are blown as far as having to deal with legal fees. So the whistleblower program, if you like, is protecting you there. Ultimately, it comes down to child safety. If you know, making sure that you're picking up conduct that otherwise might indicate that not only children but also staff are protected. It might be bad workplace health and safety practices going on, and senior managers deliberately ignoring certain things. It could be someone working from heights and the supervisor saying, look, that's all right, don't have to follow, you know, do the ropes. And at that stage, you've actually got someone, the ability to raise that up in an organisation. Next one is obviously protection of the reputation, because obviously we've seen some reputational damage through those royal commissions, but if you don't pick these things up early, the reputation of an organisation is seriously potential for serious damage. Peace of mind, and the last piece of the puzzle, to my mind, there, or the benefits, is actually, look, it's really just part of a good governance system, and we'll talk a little bit more about that as we go through. So, what are the key elements of a whistleblower program? And I'm just going to build on the conversation what I just said about the Pilar diagram previously, and just give you a little bit more detail about each one of those. So, what types of policies do we have to have in place? First of all, you know, within the program itself, usually there's a statement of commitment that the board and senior executives will make. Most importantly, from my mind, is within the program, you have the opportunity to explain the whistleblower system within the governance context of your organisation. How does it relate to your child protection incident notifications? How does it relate to your internal grievance procedures? How does it relate to your complaints handling systems, and so on and so forth? Also, it gives you the opportunity to set out key roles and responsibilities, which we'll deal with in one of the last parts of this webinar, and go through the different types. But, you know, who is the whistleblower protection officer? Who are the investigators? What's the role of the board? All those types of things that won't be in a whistleblower policy, but they need to be documented. The types of conduct to be reported, who can blow the whistle. We'll go into quite a lot of detail about that because the Corporations Act is relatively limited as to eligible whistleblowers. So there are questions that you need to decide as to how you're going to manage that. And with everybody that you say, okay, they can blow the whistle, for example, if you take parents' ability to blow the whistle, the question is, how do they get accessibility, or they need easy access to that opportunity to blow the whistle and to understand that. So that's important as well. The whistleblower policy itself, you need to detail how to make a report, what protection and support you're going to have, how you conduct investigations, and so on and so forth. Even like all programs that you have, maintenance and review and improvement. So you can see the P part of the process, the policy part of the process, is a lot more than a public-facing whistleblower policy. It's actually, and it's very similar to privacy. You can just have a policy that's published on a public website, but of course, with the iceberg analogy that I just gave you, it doesn't help the organisation understand to actually run the whistleblower service itself, which is what the program does. So the next part of it is, you know, what learning do we need to have? Now, the most obvious one is for employees and directors and officers. Of course, we can just do online induction training and refresher that explains to them the whistleblower protections and how they interrelate with the other internal mechanisms that you have within an organisation. And in many cases, you can also get suppliers to also do that sort of ongoing online training, but not always. So then when it comes down to other key stakeholders like parents and students and within an organisation, you might use alternative learning mechanisms. So that could just be communications, things like, you know, letting them know through newsletters or through a school intranet that these things are available, okay? When you get to the A, which is actually the assurance part of it, you're going to come up with this threshold decision that we're going to cover quite a few times in this webinar. And that threshold decision is, do you do everything internally? Do you utilise an external whistleblowing services, or do you do a combination of both, okay? And then depending on those decisions and the threshold decisions you make, you then have all these assurance questions like, how are we actually capturing all of this information? So there are many capture methods, and you generally need to provide multiple capture methods. Most common being obviously, you know, a whistleblower hotline, a dedicated email, a dedicated postal address, and you know, many organisations using an online form or specialised whistleblower service software. So the whole process can actually be managed. But think about this: you've got to keep records of all of these things. You can't just, you know, have going to an email, but you need some sort of, to get the reporting out, you need some sort of way of capturing that data and ensuring that it's reported properly. And the last part of the program is all about the reporting. And I've used this slide really intentionally because you can see out the front, you know, fraud, theft, bribery, abuse. These are all serious misconduct issues. So it's not, when you report this stuff, you've got to be very, very careful about how you report it, how you manage the information internally. Therefore, again, your whistleblower program needs to go into some detail about how you are doing that. And we're going to talk about that again in the practical part at the end of this webinar. So then we get to the point of, you know, and all of the things I've just talked about, by the way, are applicable whether you're a corporation or whether you're not, whether you're caught by the Corporations Act. And many organisations and certainly many of our clients that are not actually caught under the Corporations Act are actually implementing whistleblower services themselves. So this isn't something that you do just because you have to under the Corporations Act. It's actually part of good governance that you are doing this. But obviously, what everyone's interested in is how does the Corporations Act work, and you know, and what are the protections and so on and so forth. So I've broken this into two different sections. The first one is what disclosures are actually caught by the Corporations Act, because they have to be qualifying protections to actually get to qualify for the protections that are articulated in the Act. So we've broken it into two parts. So to look at what disclosures are actually caught, the first thing is that all companies, private companies and public companies that are registered under the Corporations Act are regulated entities and must comply with this these laws from the 1st of July. So and think within a school, you might actually have some proprietary companies within a structure. Many of you are public companies limited by guarantee and you're caught through that mechanism. But even if you're not, the whistleblower protections and the offences still apply to you. So as a company such as CompliSpace, this information would apply to us. So where there's some confusion that it only applies to public companies and large proprietary companies, is actually the fact that all public companies and large proprietary companies, they are the ones that have to have a whistleblower policy in place by the 1st of January 2020. Now, the important thing in here is all other companies still need to comply. They just don't have to have a policy, which is a weird piece of legislation, isn't it? Because how can you comply with the obligations under the Act if you actually don't even have a whistleblower policy in place? So it's pretty high risk for organisations if they don't make that step. But of course, if you are caught as a public company limited by guarantee or a large proprietary company, and just by the way, the definition of large proprietary company is changing on the 1st of July, and it's two out of the following three things. It is over 100 staff, over $50 million in turnover, and $25 million of consolidated gross assets. So that's actually how you qualify as a large proprietary company, okay? And you can see that there are fines and associated with not having that in place. I suppose one of the questions I'd raise here is, well, who's enforcing this? Who's the regulator? ASIC is really the regulator, but as with, say, the Privacy Commissioner, they're not what I call proactive regulators. What that means is they don't actually actively go and look at your website or go and ask you whether or not you have a policy in place. They wait until something goes wrong and then someone blows the whistle and then you get caught and then you get fined when you don't have it in place. That's very different from some other regulators out there, and certainly those of you in Victoria who've dealt with the child protection regulations or the new laws over there, or they're not that new now, but every principal in Victoria had to sign a compliance attestation with respect to the child protection laws, and that was an active piece of work by the regulator to actually say that this is the people that need it, you need to tell us whether or not you have it. So yeah, it'd be interesting to see generally what happens with ASIC and how they approach this. So who's not caught? Incorporated associations incorporated under state legislation, unincorporated associations, and then entities established essentially under Acts of Parliament. Now, there are quite a few schools that they tend to be the older schools in Australia that are actually incorporated under an Act of Parliament, and they tend to have a trustee structure underneath them. A lot of Catholic entities also fall into that structure. So they are incorporated under something like the Church, I think it's the Property or the Lands Act in different states, and then they're run by a board of trustees. They're not caught by the Corporations Act either. So what disclosures actually qualify for the protection? So we haven't even got to the protections yet. In order to be protected, four things need to happen. The disclosure has to be in relation to a regulated entity. Now that's a company, and we've just been through that. They need to be made to an eligible whistleblower. They need to be with respect to a disclosable matter, and they need to be made to an eligible recipient, right, or a designated Commonwealth authority. So it's a four-step process that you need to go through to actually even work out whether the disclosure is one that qualifies for protection under the Act. There are also two other types of disclosures, which I'm not going to go into here. one is a public interest disclosure and an emergency disclosure. Essentially what these are is where you've made the disclosure to ASIC itself, the public interest disclosure is that if ASIC does nothing about that for 90 days, you can give them notice that you're going to disclose publicly that information. And if they don't respond to that, you can go to a journalist and you can let that information, and there's no penalties involved in that. And it's very similarly with emergency disclosures. If there's an emergency need, if you like, but you need to report to ASIC first, and then you can do a similar disclosure. But that's probably beyond the scope of this this webinar. I might say that, and you'll see up just in the blue underneath the titles, I've got the parts and sections of the Act. The legal researchers that I've been working on putting this together, their view is it's not a really well drafted piece of legislation. It's actually really complex when you go in there. So can I just say today, for the purposes of this, everything that you're seeing down is very much a dumbed down version of the Corporations Act, obligations. I think we've got the essence of them, but really, if you are in the situation, need to go into detail. Getting proper legal advice around this is certainly important, because there are so many different sections that are interrelating that to give you the ultimate outcomes. So let's go to the next section. Who are eligible whistleblowers? Okay, with respect to a company, which means that obviously these guys need to be related to the company that that is the subject of the disclosure. So it's an officer or a director, an employee. The important ones are supplier of goods or services, right? And then in brackets, paid or unpaid. That's actually in the Act. And I should note on the top line here, we actually refer to current or former. So when you get into suppliers of goods and services, what that actually brings in is volunteers, because volunteers are providing services to a school and they're unpaid. And there's no time limit to this. So you can qualify as an eligible if you are a former volunteer of a school, if that makes sense, right? And then the next parts, these are really not built for schools, these regulations. They're very much built for what I call the average corporation. It then contemplates going into relatives and other dependents that I won't go into the detail in relation to that. But that's what you actually qualify as an eligible whistleblower. What's really important probably is not who are eligible whistleblowers, but who are not. And this is really important for schools. So students, parents, staff of other schools, and why I've added them, schools are very collegiate. In my experience with schools, they often go on excursions together. They're often doing collaborating in relation to arts and drama. We've got representative sports teams and so on and so forth. So a staff member of one school on one of those situations who sees a staff member of another school do something, and I know that there's child protection requirements beyond that, but it might be, slipping money to the bus driver or something like that, which isn't caught under that sort of child protection legislation, and they had a suspicion. Well, they're not an eligible whistleblower as far as the other school is concerned. And there would be lots of other key stakeholders that you could look at, whether it's alumni, and certainly in faith-based organisations, you've got clergy and so on and so forth. So these people don't fall within the eligible whistleblower qualification. So just try and pull it back. Four steps that you've got to cover to be eligible. So we've covered the first two. The third one is it's got to be a disclosable matter. And this is pretty broad. So in order to be a disclosable matter, you have to have reasonable grounds to suspect that the disclosure concerns, and here you've got misconduct, a very broad concept, and improper state of affairs or circumstances. And what's important is those things. Misconduct is actually defined under the Corporations Act, and you can see that brings in things like breach of trust, breach of duty. The improper state of affairs or circumstances is not defined. So that's actually the test as to whether or not it's a disclosable matter. I would suggest that that is very wide. So most matters would fall as disclosable matters within the Act. It's not just criminal type behaviour, but it's certainly breach of values and other things like that certainly would fall within improper state of affairs or circumstances. Interestingly enough, the Act goes beyond, it gives this broad definition, but it then, expands on it, but it doesn't limit the broad definition. And you can see it talks about offences and, imprisonment for a period of 12 months. But don't let that stuff fool you, because that isn't actually the test. The test is this, misconduct. It's a much broader test. There is one thing that's carved out, however, and that's personal work-related grievances. And this is quite a complex part of the Act as well. We've just summarised it back down here. So it excludes personal work-related grievances of the whistleblower, right? But not victimisation for actually whistleblowing. And they just give some examples there, personal conflict and so on and so forth. Now, these are exactly the sorts of things that you'd expect to run through an internal grievance procedure in your HR program. So there's three of the qualifiers. These are to qualify for protections. And the final one is that it needs to be provided to an eligible recipient. So who is an eligible recipient? Essentially, the first two, being a director or a senior manager, is both of those, if you combine them, they fall. Those of you familiar with workplace health and safety legislation would understand these definitions. Essentially, if you make or participate in a decision which affects the whole or a substantial part of the organisation, or you have the capacity to affect significant financial standing in an organisation, you would fall in the senior manager / director officer eligible recipient, okay? That would mean certainly principals, business managers, potentially go down to heads of campus. The line under that about auditors is just important to understand. This is just Corporations Act audits, which tend to be financial audits required under the Corporations Act. So they're required for large proprietary companies and public companies as well. So it's the auditors of those companies that are the ones that fall into this disclosure bucket. What it doesn't include is a workplace health and safety auditor or a child protection auditor or any other type of auditor, because we use the term audit quite broadly, okay? Now, the last one is about a person authorised by the company to receive disclosures, and why we've highlighted that is to be authorised by the company. You probably arguably need to be authorised by the board. That comes down to, the whole process of the board's relationship to this whistleblower program. And certainly from the internal discussions we would suggest that the whistleblower program itself should be approved by the board, but certainly the people authorised or the whistleblower protection officers that are actually authorised should be authorised at a board level. And that's whether they're internal or external, okay? Just note also that disclosures, they're not under the definition of eligible recipients, but disclosures can be made to ASIC, APRA, or any other prescribed authority under the regulations. I put the ACNC there because, it would be a very small jump here. The bizarre thing about this whole law is half of the not-for-profits are caught because they're public companies limited by guarantee, and a lot of the other ones aren't caught. And it seems to be quite random as to whether you're being caught under this legislation or not. Depending on where this whole thing goes, it wouldn't be a very big jump for the ACNC to say, well, if you're a registered charity of a certain size, you also need to have a whistleblower program and for them to be added. So it's actually built, the law is built in such a way to be able to expand that through regulations is something that we'll probably see moving forward. In fact, there's a lot of things within this legislation which are quite confusing at the moment, and we'll talk about that in the protections. So it is likely that the regulations will follow, and they will give more clarification. So there you have it. To be to qualify for protections, it's got to be to a regulated entity, regulated whistleblower, has to be a disclosable matter, and you have to make sure it goes to the right recipient. So there's a hurdle to get there, even before you look at the protections themselves. So if it is a qualifying disclosure, qualified disclosure, what protections do you actually get? Now, again, you can see all those pieces, the sections of the Corporations Act they're up on top in the blue line. We've made this really simple as far as try to explain what those protections are. Again, it's quite complex legislation. The first one is confidentiality and anonymity. Second, limited liability. Third, around prohibiting victimisation, and the last one, the bottom two really fall together because they're all about detriment and the effects that if you engage in detrimental conduct to a whistleblower, those protections then link in. So I'll go through each one of these quickly. First of all, there's no requirement under the Act for a whistleblower to identify him or herself. And then you come into the confidentiality provisions. Now, if a person wants to keep their identity confidential, and so you don't actually disclose your identity, right? It's a contravention of the Act, and we'll see what happens in the next slide if you contravene the Act. If the information about the identity, right, of the disclosure, or information likely to lead to the identification of the disclosure, right, and the person obtained that information because of the disclosure, and if that is disclosed and the disclosure isn't authorised. Now, that's pretty broad if you think about it. So if you said, I don't want my identity disclosed, and someone discloses information likely to lead to the identification, then it's a contravention of the Act, okay? So it's fairly broad as to how that works. But of course, like all these things, there's a lot more under the hood. Now, if you do contravene the Act, so you actually disclose this information, these are the penalties. So the first two penalties I'll just broadly refer to as criminal penalties. One is imprisonment, and the other one is fines of up to certain levels that are associated with those criminal offences. And the second ones are civil. The difference obviously being that criminal offences have a higher burden of proof than the civil, civil obviously being balance of probabilities and criminal being beyond reasonable doubt. So that's a difference, if you like, between the two. In both cases, you know, proving those things, and you could, the ASIC would take actually an action on a civil penalty, and they didn't have to make a contravention order, and that's when these things would actually link in. The scary part is actually that the $200,000 and the $1 million are just about to shoot up quite rapidly to just over $1 million and $10 million for companies under amendments made to the obscure act called the Strengthening Corporate and Financial Sector Penalties Act. And there's no guessing where that came from, pretty much straight out of the Royal Commission, the Banking Royal Commission in this case. So the penalties for contravention is really, you know, the protection if you actually release this information. So what are the outs, okay? And the main out here is it's not a contravention of the Act, okay? If you disclose the information and it was reasonably necessary for the purposes of investigating a matter, and the person who discloses the information takes all reasonable steps to reduce the risk that the identifier will be identified. And yep, it's a lot of information, and you've got to take a big breath on this one. It all comes down to the quality of your internal whistleblower service, that you are making the people that are dealing with these incidents and disclosures are well trained to be able to manage them, right? And they understand the steps that are being taken and when they maintain confidentiality, and they need to understand very carefully on how to manage an investigation properly. So even though it looks like this massive out, it really does, and this is one of the really big risks from my perspective for schools, if they don't actually have a whistleblower program. So when a disclosure comes in, they're not really aware of how to deal with it, and they could easily breach this section by releasing somebody's information or identity, and they didn't take reasonable steps to reduce that risk. You've got to say, however, that when you look at this, it's a bit of a minefield, because ultimately a court of law is going to have to make a determination as to what's reasonable and what's not reasonable. So it's going to get quite complicated. Importantly, in the prosecution of the defence, it's the defendant that bears the evidential burden. That means it would be the school itself that has to prove that it took reasonable steps in this circumstance. So, it's an interesting protection. The next one is limited liability. And what that means, and I don't think this is a huge protection personally, but because what it's saying is your liability, you're not subject to, criminal, civil, administrative liability. It's actually for making the disclosure, right? Not your conduct, but actually making the disclosure. And similar for contractually on the basis of the disclosure. So if you look at this protection, if you like, it really focuses on limiting liability with respect to the making of the disclosure, with the exception of if it's false. So in the last line of the third bullet point, that you've actually provided false information in the disclosure, and then you could be liable for that. What's really critical is the section in the Act, or the commentary in the Act, that says very clearly that the limited liability provision, it does not prevent the disclosure being subject to liability for conduct revealed by the disclosure. So it's subtle, but the difference is making the disclosure, so you're protected because you made it, but you're not protected with respect to conduct that is revealed by the disclosure. So, I wouldn't be jumping up and down if I was a whistleblower about that one, if I had also engaged in conduct, because I'm not getting any limitation of liability for that. It's not like you're getting a plea bargaining deal when you go through. So that's the second one. The third one is in relation, and as I said before, the victimisation and compensation, they're actually tied up together in the Corporations Act. We've just broken them up to make them a little bit clearer here. So just looking at prohibiting victimisation. So victimisation is defined as actual or threatened detriment, and I'll show you what that means in a second. And if you do that, or someone engages in actual or threatened detriment, it's an offence, and then a whole lot of things run from that offence. Again, similar penalties. So what is detriment? Detriment is defined in the Act, and it's pretty broad. So in relation to an employee, as you can see, sort of dismissal, injury, basically all those general employment-related misconduct, if you like, or detriment. So if you're doing any of those things because the person blew the whistle, right, that's detriment. And generally, you've got all the things that you're more thinking about victimisation, which is harassment, intimidation, and you can see the last line there in relation to, it's very broad. It's even, a person's reputation, any other damage. So it's broad as far as what detrimental conduct is. So what happens if you actually engage in this conduct, which is, actual or threatened detrimental conduct? So here your penalties come up again, and what you'll see is the prison term's gone up, the fine's gone up, while the civil penalties are the same. Okay, so there's there's a serious consequences for organisations that allow or don't know what they're really doing when it comes to whistleblowers. And if someone makes blows the whistle or makes a disclosure that qualifies, they're not managing that disclosure properly. And you can see the significant penalties that are actually associated with that. If we follow the detriment, so that's more around your sort of criminal type activities. And then there's a whole lot of other remedies that also flow off detriment. So in this case, you've got compensation, injunctions. You can see all the related things there, apologies, any other order. So it's very broad. The burden of proof here flips. So it's actually, if you have experienced the detrimental conduct, i.e. you're the whistleblower, right? All you need to do to prove is that there was a reasonable possibility that the conduct occurred. It's not a very high threshold. So that person has the initial onus to prove that there was a reasonable possibility. And once that onus is discharged, it's the school or the person to whom this claim is being made against who has to has the onus that the claim's not made out. So yeah, again, it's a fairly strong protection in that regard because of, as the last one was in relation to flipping the burden of proof. The other thing for schools to be aware of is this vicarious liability concept, because it may be a person who's engaged in detrimental conduct in the school, right? If they're an employee, the school can be liable for the actions of the employee unless the school took reasonable precautions and exercised due diligence to avoid the detriment, and they actually gave effect to its own whistleblower policy. And look, this is, without saying the obvious, this means you can't just afford to whack up a policy, copy it off someone else and hope for the best, because if you do, and something happens, and that whistleblower goes to an officer or a person who you can make a disclosure to, and so it qualifies under the Act, suddenly the school's going to be liable if it hasn't managed it properly. If the school can prove that it's got a proper system for managing whistleblower complaints, and it was a rogue employee, if you like, that did it, they won't be liable, and the fine will land with the employee rather than the employer being the school. So again, this is highly simplified under the Act, and but it should give you a bit of an idea as the sort of protections that are there. They sort of fall into those four general buckets. So the next one I just wanted to go through is the key operational issues in implementing a whistleblower program, and we'll run through these. The first thing to note is that I've said whistleblower by design because I think it's the first principle of the Australian privacy principles actually refers to privacy by design and says you must take a whole of business approach to this. You can't just have a policy and hope for the best. So it's very similar with whistleblower, that every school needs to design the program for their own requirements, okay? And whether you are caught by this or not, whether you're caught by the Corporations Act or not caught by the Corporations Act. So you're going to have to make decisions about whistleblower coverage. Are you extending this to students? Are you extending it to, more broadly to key stakeholders? Are you using internal or external whistleblowers services that I've talked about? And one of the things that so we have basically drafted our program in two ways. One for organisations that aren't companies, and one for organisations that are companies. And what you see very clearly there is if you're not caught by the Corporations Act, you still offer these protections to whistleblowers. So you offer protections about not victimising them, making sure that they're not adversely effective through internal administrative decisions, providing protection and support. So you provide those. The Corporations Act builds upon those, if you like, okay? So really, you've got to make sure that as a school, it fits what you need to do, okay? The next critical thing from an operation perspective is you've got to make a decision as to whether you're going to use an internal, just do everything internally, or whether or not you're going to use some sort of external whistleblower service, or you're going to use a combination of both of those. And, you know, we've seen all of those, you know, internal only, external only, combination of the two coming through. So the two decisions that you have to make here is your whistleblower protection officers. Are you actually getting an outside party to act as the whistleblower protection officer? So they're the, you know, an external service is going to actually take that initial disclosure. And the second one is, do you use internal or external investigators? Now, the size, nature, and complexity of your organisation is absolutely key here. And the best way I can describe this is, if you're working in a bank, for example, and you've got 100,000 people, that bank can have an internal professional integrity unit, and that can be very independent and employees in the company can feel safe to actually go to that unit. If you are a very small school, that doesn't work very well, does it? Because if you say blow the whistle to the principal and to the chair of the board and everyone knows each other, it doesn't really work. So the smaller that you are, interestingly enough, the greater the argument that you should use an external whistleblower service. The advantage of using one is that when it comes to anonymity, personally, I would be a lot more willing to say, provide my identity to an external provider, knowing that that external provider, that their brief is not that no one in the organisation would ever know my name. Their job is to play the go-between between me as a whistleblower and the organisation. And that allows you to properly carry out investigations. Because if someone comes in and they say, look, I was sexually harassed by someone at work, but I'm not going to tell you who I am. It's nearly impossible in that circumstance to do anything about it, right? Because how can you make an investigation if you actually don't know those circumstances? The second thing that I would say, and this is really under anonymity and investigation risk, the other thing that I would say is actually the expertise of a whistleblower, how important it is that the whistleblower protection officer, when you're actually receiving a whistleblower disclosure, you really need to know what you're doing. And you could get these are serious incidents, and quite often the people making those calls will be quite distressed or they'll be very nervous. So the person taking the call, their job is to really work to protect the whistleblower, settle them down, explain the circumstance, but they also need to understand criminal and the law, because they need to understand, for example, in certain states, I think in New South Wales, Northern Territory and Victoria, there's very broad requirements for any person who is has knowledge of a child abuse incident to actually make a report to the police, right? So the people receiving those really need to know what they're doing. So big question for everyone, internal or external, combination of both. So who are these external providers and what do they do? Well, generally what the external providers, just go onto Google and type in external, or just type in whistleblower services, and you'll see a whole lot come up there. They fall into some broad categories, if you like, from my perspective. There's the specialised whistleblower services. These are organisations, they don't do anything else, and they're there, and they've been around for quite a long time, and they are there to provide a specialised whistleblower service. You then have nearly every single one, I think, of the big four accounting firms providing whistleblowing services. And also, if I go further to that, I'm seeing a lot of medium-sized accounting firms starting to do so. A lot of law firms are starting to provide whistleblowing services as well. So I think we have internally about 20 or 25 that we've identified that are actually actively providing whistleblowing services. So what do? What they actually do is, think of them as your external whistleblower protection officer. So they're the person whose job it is to protect the whistleblower and walk them through the whistleblower process. So to protect their anonymity if they've requested it, but also to explain the whole process and go back to them with respect to questions to clarify issues on investigations. So How much do these whistleblower services cost? Well, of course, I don't know exactly, but I put that in simply to explain that there's a very logical thing here. The cost of providing any service is related to how often you use the service. So I think most providers will price their services based on the size of your organisation and the likelihood that they will receive disclosures. So in many cases, they might say, look, it's unlikely you're even going to get a disclosure during the year, and it might be quite low, but if you've got 30,000 employees, it's going to be a different a set of circumstances. The really important thing from my mind, think a little bit like an insurance policy. The stronger your internal governance systems, the less likely it is that you're going to have to blow the whistle, right? Or you're going to have the whistle blown because people are going to go through those internal channels. So you should be able to demonstrate to service providers that in fact you have a strong governance infrastructure and that it's actually structured so only the serious complaints go. So you're not paying for what I'll call false disclosures or disclosures that don't qualify under your own policy. If we come to whistleblower service and investigation service, just one thing, be really clear, they need to be independent. You will see a lot of these whistleblower services, they have related investigation services, which is fine, but the actual process, you can't have the whistleblower protection officer, the person taking the phone call, can't be the person doing the investigation for obvious reasons, so they need to be independent. So you need to, and that's where I'm coming down to this question of due diligence. Certainly if you're going to appoint an external provider, you need to be very clear on what they are actually doing, what services they're doing. The most important thing for me would be who's answering the phone. I don't want to go to a service that has, you know, third-year law students answering the phone that aren't trained. I want to make sure that I'm going to an organisation that has the people that are answering the phone are highly experienced and can deal with the range of matters that are likely to come from schools, i.e. most critically, you know, if you've been dealing with banking and finance, you're never going to have had a child protection issue come through, but it is likely in schools that the external providers will get child protection related disclosures, and you need to make sure that your provider has people that are trained to deal with those. Obviously, other issues are, you know, how often, you know, is it a 24 by 7, 365-day a year type of service? And there's a whole lot of other questions you'd ask, but I just wanted to highlight that. So as we go through on key roles and responsibilities, these are sort of the key roles and responsibilities. They can change, the names can change, but you need to very clearly articulate the role of the board. We touched on that before when we said that they need to really approve the program and also the key whistleblower protection officers, the people that are actually authorised to receive disclosures. They can be internal or external. Whistleblower investigators are really, really key because you're going to have a range of investigators investigating different things based on the type of disclosure that's been made. In a school, I would have thought you also need to have a role which I'll broadly call a whistleblower program manager, or that person could also be, I mean, is likely also to be a whistleblower protection officer. But that person's role is to make sure the whole program is working properly, it's up to date, it's being maintained, people are being trained properly. So all the normal sort of governance aspects, you need someone, just like in charge of privacy, in charge of child protection, so on and so forth. You need somebody in your organisation that is a whistleblower program manager. So then you've got to come to this question of how far are you going to extend the blow the whistle, if you like, and who can blow the whistle. So you've seen under the Corporations Act on the left-hand side, these guys can blow the whistle under the Corporations Act. The real question is, it's not designed for schools, but to do this properly, you really should be extending it across to parents, allowing them to actually raise issues, because they will often see things that should be raised, and things that don't necessarily fall under complaints or any other structure. So they might want to make those types of disclosures. And I've raised the other issues. Why I've raised this here is who you decide can blow the whistle has a direct effect on how you're going to build your program. Because when you're looking at or your internal people, it's very, very easy. You can have a policy published on your intranet, but nothing on your public facing website. So the law doesn't say what you have to do here. There's no law that says you have to put your whistleblower policy on the public website. So as you design your program, you've really got to start thinking about, look, if we want parents to get this, how do we do that? Now, obviously, the whistleblower program will be one thing on the public website that is clear, but you've got to let them know that it's there. And that quite often will be communications through newsletters and other ways. You might have briefings for parents and students and so on and so forth as you go through. So this is where I was talking about the design issue, that you really need to design it carefully. And then just to re-emphasize this point, and this is the diagram we had earlier, which is, you know, your school's here and the whistleblower is going, well, how do I actually report things up? You know, what are my internal reporting channels? Well, you know, think about these. They're numerous within a school. Complaints. Okay, do I go through the complaint system? Is it something about your service? Do I go through a child protection notification? So we all have child protection policies on our websites, and they have notification processes through there. Human resources, you've got a double barrel in your human resources program, well, even triple. Often there's things like, you know, suggestion boxes and things like that. The most important, probably the internal grievance procedure. So you want to make sure that your whistleblowers have the opportunity to raise grievances through that process, rather than going through the whistleblower system. And of course, you also have discrimination, harassment, bullying type issues that come within that program as well. That you want to make sure that there's clear communication channels and notification channels before you get to the whistleblower program. Workplace health and safety obviously has the same sort of thing. If you see there's a risk or a danger, you need internal reporting mechanisms. Privacy, when you see privacy breaches, data breaches, all of those things you've got internal systems for. And then you've got the specialised things around boarding or overseas students. But a lot of organisations have fraud and corruption control programs in place as well. And within those, you have a notification process on who to go and talk to if you see that happen. All of those, if you're a whistleblower, the more choices that you have, the clearer it is for you, the better trained you are as to where to go, you're more likely to go up into that school. So instead of, you know, your question mark disappears, if you like, and you go, actually, I know what to do here. And that stops the whistle being blown to the protection officer. You're taking the heat out of the whistleblower program, which is really important for two reasons. One is, if you are under the Corporations Act, if it goes through the whistleblower program and qualifies as a qualifying disclosure, you are liable for all those protections. You have to keep those protections. You're liable for all those offences and possible civil penalties that arise. So you want to make sure that you're avoiding that process as you go through. So, yeah, the stronger your actual internal processes. The other thing is that they will also have a direct reflection or relationship with the potential cost if you use an external whistleblower program. Because just as you go to an insurer and say, actually, I'm much more unlikely to have an incident occur because I've got great governance systems, you could have the same argument with an external whistleblower provider and say, actually, I know we're this size, but we've got really good internal systems. So the likelihood is you're only going to get, you might average, you know, X number of whistleblowers per 100 staff or whatever for organisations generally, but we have really good systems, so we're going to be less. And it may be an argument for you to reduce the costs in relation to using an external whistleblower provider. Just right at the end of this management and board reporting, I just wanted to highlight this as a separate issue. You need to have very clear internal processes about individual disclosures. Why you need that is it must be on a need-to-know basis, and you've got to be very, very careful about who gets that information. So you don't just go, hey, the whistle was blown, let's tell the board. You're not going to do that. Each individual disclosure needs to be dealt with on its own merits. You know, if it relates to the principal, obviously, you just don't tell people for the sake of telling them. You need to manage the disclosure first. Then what you need to do is think about how you're going to report up to the board. Now, some of those individual disclosures, it might come up to the chair of the board who actually decides that the board needs to know, or it may not go to the board. But generally, the board's got to get, broader reporting as to the whistleblower program and its performance. And that's where I've made the reference to zero reporting. The best reporting you could ever have as a board member is that you've got a really robust whistleblower protection program in place, and you get zero reports, which means every month or every quarter, whatever your cycle, you get a report that says we have had no whistleblower disclosures under our whistleblower program. And that would be music to the ears of most board members, because if they set this thing up properly, that's a pretty good radar to say that everything is working in your school. The very last part of the program, it's only just a couple of slides. We often refer to the school governance puzzle, and it, quite often is completely overwhelming. There's so many things that you have to do as a school to make sure all of this comes together. Just from our personal experience, there's a sort of sliding scale to this, if you like. Most schools in the first instance will focus on those really high-risk areas. So the risk and compliance programs themselves are obviously core infrastructure for governance, but they're going to focus on child protection, workplace safety, student duty of care, getting rego right before they generally put in a whistleblower program. Could you imagine putting in a whistleblower program if you didn't have a child protection program or you didn't have a workplace health and safety program? That would be a major worry, because probably the first whistle would be blown is that you don't have those things in place by people that know what you're actually doing. So you've got to build your governance structure up to make sure that the whistleblower program is working effectively and giving you the best outcome. In our experience, once you've got that first governance block in, you then look at the second block. That is how your board's working, the boardroom online type programs that allow very clear reporting and transparency at the board level, putting in your human resources program with internal grievance, EEO, those types of issues, and the other specialised modules. All of those are highlighting your internal processes for managing incidents, which will avoid things going through whistleblower. Probably the third level is around fraud and corruption. We all know that fraud and corruption works in schools, but again, you tend to be focusing on other things like human resources and complaints before you go down that line. Now, really, the benefit of a fraud and corruption program really goes hand in hand with a whistleblower program. The program that we've designed internally, the most important part of it, and there is actually an Australian standard for this, the most important part of it is you're actually training your staff as to the fact you have an internal fraud and corruption program and what falls under that. So, taking a pen home isn't going to fall under it, but taking a box of pens home or taking large amounts of stationery and things really is theft, and that comes potentially under that, all the way to the much more complex type fraud situations that you have in schools. And from our discussions with schools, they happen a lot more than are publicised. Generally, they're just not publicised. The great thing about fraud and corruption is the whistleblower program just works in with it beautifully, because people tend to blow the whistle on fraud and corruption, which is probably where a lot of this started in the first place. And just now to the last slide, what's your risk profile on all of this? Well, it will very much depend on your structure. School groups will have a very different risk profile from individual schools. At one end of it, if you fall under the Corporations Act, you are going to have compliance risk, because obviously if you don't comply, you've got serious risk around that. So look, really from my perspective, just throwing up a whistleblower policy on your website and not doing all the rest of the work is an extremely risky thing to do, because you're likely to get caught. At the other end of the spectrum, if you are not caught by the Corporations Act, you don't need to do whistleblower by law, but you're missing a great opportunity to close the loop in your governance program. And in the middle, it's all about the risk associated with your existing internal governance programs. I was talking to a client this morning, and we were just talking about how over the last 5 years, school governance has just changed completely 5 years ago, you could be non-compliant with most things. You can't be non-compliant. Everything's changed. Registration cycles have changed. You know, expectations of child protection have changed. And this is just the next thing. So really, there's been a maturing of governance, and interestingly, this whistleblower law, as it's come in, really raises the bar yet another level for schools. So I hope that was useful information for everyone in relation to it. I know it's a lot to take in. It's a pretty complex area. I'm sure you've got lots of questions. So can we do it this way? If you, on the chat feature of the software we're using for the webinar, just send in any questions that you have. If you don't, if you log out of this and think of a question, send it through. If you're a client, send it through to your client relationship manager. What we're going to do is collate all of those questions, and then we will send everyone a sort of frequently asked questions response. So we respond to everyone with respect to all of the questions. We'll also send you a link to a page on our website which just describes our whistleblower program, fraud and corruption, all the related modules like human resources and so on and so forth, that all are key to the ongoing management of your governance program and compliance with whistleblower legislation. And lastly, of course, if you are a client again, just feel free to contact your client relationship manager. If you are not a client, just come through the contact us section on our website, and we'll get one of our guys to give you a call on that. So thanks very much, everyone, for joining us. And that's the end.